I'm federal criminal defense attorney Ryan Pacyga, and I'm going to talk about what happens when somebody is arrested on a federal crime and then what a detention hearing is about. If there's a federal complaint for alleging federal crimes, a judge has to issue a warrant for your arrest, or if you're indicted by a grand jury, you'll typically be arrested by the US Marshals and brought before what's called a magistrate judge in federal court, usually as soon as possible. A lot of times it's the same day, sometimes it's the very next morning. When you're brought before the federal judge on this federal arrest warrant, then the government, which is the prosecution, they have a right to ask for what's called a detention hearing if they want to, or the judge can decide that they want to have a detention hearing. And a detention hearing, it's different than in state court. A lot of times in state court, people think about posting money bail to get out, while they're arrested before they have to go to court. Federal court doesn't happen that way. Usually what happens in federal court is you either sign a signature bond, which is a promise to pay and then you're released, or there's a detention hearing, or there's some things in between those things. If the government asks for a detention hearing, or the judge does, there are certain factors that have to be met to qualify someone to even ask to have a detention hearing about you, okay? And there's a list of factors. I'll read them off for you. So if the prosecution alleges that this is a crime of violence, for example, a robbery, or if this is a terrorist offense and it carries a penalty of 10 years or more, or if it's a case that involves a maximum of life in prison or the death penalty, or if it's a drug offense that carries a maximum of 10 years or more in prison, if it's a felony that you've committed after you've already been convicted of 2 or more of the things I just talked about, or it's a felony that's not a crime of violence, but it involves a minor, which means under the age of 18, victim, or possession of a firearm or a destructive device like a bomb, or failure to register as a sex offender, or they allege that you are a serious risk of flight, or that there's a serious risk that the defendant will obstruct or attempt to obstruct justice or threaten, injure, or intimidate or attempt to do any of those things to a potential witness or juror. Any of those factors, the government or the judge can ask for a detention hearing. You have a right to challenge that with a lawyer, and when we do that, sometimes we can convince judges not to hold a client in detention and instead do an alternative like a signature bond where there's a promise to pay and you have to follow rules like maybe random drug testing or wearing a sweat patch or weekly meetings with a probation officer. You have to give up your passport sometimes so they don't have to worry about you fleeing the country. Sometimes it means you go to a halfway house instead, or you wear a GPS bracelet so they know where you're going and things like that. Those are some of the alternatives that can be done rather than being in detention. Obviously, it's nice because if you're in detention, that means you're sitting in a jail the whole time your federal case is going on, which can last anywhere from kind of a month at probably usually the minimum, up to sometimes as long as a year or more. So people prefer, obviously, not to be in detention and to qualify for one of the alternatives. If you have questions when someone's been arrested or is about to be arrested on a federal crime, I'm criminal defense lawyer Ryan Pacyga. You can call me at 612-339-5844 or find me at arrestedmn.com. I defend people accused of serious federal crimes.